Friends, I welcome you all at Swayam platform. Today we are going to start our discussion on the ground of divorce which is associated with the mental soundness and other grounds of the divorce. Friends, before starting anything, I want to conclude my lecture what we discussed in the last class. Friends, in the last class we discussed about the ground of divorce, especially about their desertion and conversion, where we discussed the animus diserdendi, factum diserendi, and there is no consent and there is no such kind of conduct. We also discuss about the actual desertion, constructive desertion and willful neglect. But very important point is, suppose a person filed a case against other spouse on the ground of desertion, the court may provide alternative remedy of judicial separation. But in the case of conversion, if either party presented a petition, then the court have no option, court will grant the conversion, friends. But conversion means conversion outside the definition of Hindu. If a person converted in Buddhism, Jainism, Sikhism, this is not a conversion for the purpose of law and therefore there is no remedy in this regards available, friends. Friends, so now I want to focus on the today's lecture, and today's lecture we will focus on the mental soundness and other ground of divorce, where friends we especially focus on section 13 subclass 1 where mental unsoundness. We also discuss the venereal disease, we also discuss the presumptive death, we also discuss the religious to enter into the religious order, and then we also discuss the frustration theory where we discuss the section 13 under bracket 1 capital A of Hindu Marriage Act. So these are the scheme of today's lecture. The learning objectives of the today's lecture includes: first, meaning and the concept of unsound mind and mental disorder. Second, unsoundness of and mental disorder as a ground of divorce. Venereal disease in a communicable form as a ground of divorce. Renounce the world by entering any religious order as a ground of divorce. And the fourth is person not to be heard for a period of 7 years as a ground of divorce. And after that we also discuss the frustration theory where there is no cohabitation after the decree of judicial separation as well as after the restitution of conjugal rights. Friends, so now I want to focus on the mental unsoundness as a ground of divorce, friends. Friends, mental unsoundness has been a ground for both divorce and judicial separation since the very beginning of the Hindu Marriage Act 1955. Section 13 subclass 3 provides an incurable unsound mind or mental disorder of the spouse as a ground of divorce. Friends, original provisions before the amendment in the year 1976 was quite simple, and the provision was other party has been incurably of unsound mind for a continuous period of not less than 3 years. The provision is amended in the year 1976. Now we have a legal framework related with the mental soundness and unsoundness under the marriage law. Friends, the concept of mental soundness and unsoundness is relevant at 3 places under the Hindu Marriage Act. One is section 5 subclass 2 where it required for the condition of a Hindu marriage. This is a ground of the voidable marriage. In a case of unsoundness, a party may proceed for the unvoidable marriage, and this is also a ground of the divorce. So therefore the idea of mental unsoundness must be explored properly, because marriage have a purpose. If either party of marriage is not behaving well, they are not in positions to behave well, due to their mental sickness, they cannot enjoy the marital life. Another spouse may be frustrated due to the fault of other party. Therefore, mental soundness is a key of happy and healthy marital life. Therefore, this is also recognized as a ground of divorce under the modern Hindu law, friends. So now I am going to explore the each and every dimension of this topic, but be careful that this may be utilized when you are interpreting section 5 subclass 2 or when you are interpreting the provisions of section 12 of Hindu Marriage Act. In both the context, the definition of this mental unsoundness, mental disorder is relevant, friends. And if you want to draw a conclusion about the mental soundness or unsoundness, you must focus on these combo provisions, friends. Friends, so now I want to focus on section 13 subclass 1, which provides that any marriage solemnized whether before or after the commencement of this act may on petition presented by either party, by either the husband or the wife, be dissolved by a decree of divorce on the ground that the other party has been incurable of the unsound mind or has been suffering continuously or intermittently from mental disorder of such kind and to such an extent that petitioner cannot reasonably be expected to live with the respondent. So this is the provisions of mental unsoundness. Friends, on that basis we are able to draw the different conditions related with the mental unsoundness. The spouse of the petitioner has been incurably of unsound mind, has been suffering continuous or intermittently from the mental disorder. The nature of these conditions are such that the petitioner cannot reasonably be expected to live with other party or respondent. Friends, now I want to focus on the definition of the mental disorder. The idea of mental disorder is explained under section 13(1)(3) in the explanation, friends. The expression mental disorder means mental illness, arrested or incomplete development of mind, physiotherapeutic disorder or any other disorder or disability of mind, and includes schizophrenia. Friends, further explanation B of section 13(1)(3) define the term psychopathic disorder. Means an expression psychopathic disorder means a persistent disorder or disability of mind, whether or not including subnormality of intelligence, which result in abnormally aggressive or seriously irresponsible conduct on the part of either party, and whether or not requires or is susceptible to the medical treatment. So these are the definition given by Hindu Marriage Act in order to explain two concepts, mental disorder and psychopathic disorder. Psychopathic disorder is considered mental disorder, therefore mental disorder is a wider concept which also includes psychopathic disorder. And if a person is suffering with mental disorder and psychopathic disorder, then it is a ground of the divorce. But we should be careful about that. Presence of disease is one thing and effect of disease is another thing. What disease does is more important than whether disease exists or not. So we should be think when we are interpreting this provision, friends. Friends, in order to explain the idea of mental soundness and unsoundness, we may take inspirations from the English law because the law is copied and developed on the basis of the law, English laws, friends. Therefore, I want to quote you the UK Mental Health Act 1983, where in section 1 subclass 2 they define the idea of mental disorder. Mental disorder means any disorder or disability of the mind, and mentally disordered shall be construed accordingly. The UK Mental Health Act defined two terminology, Mental disorder is one and second is mentally disordered. So mental disorder is a state of mind. Mentally disordered is a person who is suffering. So this is the definition of UK Mental Health Act. On that basis, we may construe and interpret the provisions, friends. Now I want to focus on the practices of the UK court on the mental disorder, friends. Friends, a case W versus L decided by the Queen's Bench in the year 1974, where Justice Lawton defined that the word mental illness are ordinary word of English language. They have no particular medical or legal significance. The court should construe them in accordance with the advice of Lord Reid in Brutus versus Cogens in the year 1973. So Lord Justice Lawton refer Lord Reid in order to explain the idea of mental disorder, friends, or mental illness, friends. And what is decided by the Lord Reid in Brutus versus Cogens, the ordinary word of English language should be construed in a way that ordinary sensible people would construe them. So mental illness should be construed like an ordinary man may construe this terminology. We should not apply your intelligentsia, scientific knowledge, medical knowledge in order to decide this term. Reasonably we decide whether he is mentally fit or not, friends. Friends, the Department of Health and Wealth Office Code of Practices 99 noted that incomplete or arrested development of mind implies that the features that determine the learning disability were present at some stage, which permanently prevent the usable maturation of intellectual and social development. It includes person whose learning disability derives from the accident, injury or illness occurring after that point, usually accepted as a complete development, and any other disorder or disability of the mind is not defined in the statute. So this is a general practice of the department. On that basis, we are able to draw our conclusion about the mental disorder and mental illness. If mental disorder, mental illness presents and affected the nature of marriage, then it is a ground of divorce. Friends, two forms were accepted in the English law. One is the several mental impairment and mental impairment. Psychopathic disorder, and psychopathic disorder is significant impairment of intelligence, abnormally aggressive in social functioning, and seriously irresponsible in conduct. These are the points. On that basis we may draw the conclusion, friends. How we can explain the idea of abnormally aggressive? Any person of this category should be based on observation of behavior which lead to conclusion that the action are outside the usual range of aggressive behavior and which cause actual damage and or real distress occurring recently or persistently or with excessive severity is abnormally aggressive. Abnormally aggressive means also mentally disorder, friends. Friends, one thing, abnormally aggressive and your aggressiveness also affect your social behavior. This also very crucial for the purpose of determining the case, friends. Social function test. The evidence of the degree and nature of social competence should be based on reliable and recent observation, preferably from a number of sources such as social worker, nurses, psychologists. Such evidence should include the result of one or more social functioning test. The social functioning test is also required in order to understand whether your effect, your disease is affecting your marital relationship or not, social relationship or not, friends. An assessment of irresponsible conduct should be based on an observation of behavior which shows a lack of action taken and where the act caused actual damage or real distress. Friends, the term idiot is also sufficient. Idiot means a person so deficient in the mind as to permanently incapable of rational conduct. If either party of marriage is idiot, it is the ground of divorce, friends. Lunatic, it is used to cover all form of insanity. The technical definition of mental disorder, mental illness, incomplete development of mind, I want to focus on the certain observation. All the mental abnormality not recognized as a ground of divorce. If mere existence of any degree of mental abnormality could justify the dissolution of marriage, a very small number of marriage could be sustained. Therefore, friends, I quoted number of time, the presence of disease is one thing, consequence of disease is another thing. We will rely on the consequence of disease. What actually happened due to the disease. The next point is, friends, the mental disorder must be such a degree and nature which mitigates against the continuation of marriage. Means degree and nature of mental disorder is very crucial in order to decide the cases whether mental disorder exists or not, friends. And therefore, friends, we have only one test, and test is whether conjugal life is impossible or not, and on that basis we will determine the ground of divorce. What is the consequence of the mental disorder, friends? As I discussed with you, friends, mere existence of some unsoundness of mind or mental disorder is not sufficient for the grant of divorce. The difference between the parties have reached such a degree that it is no longer reasonable to expect the petitioner to continue to cohabit with respondent. In such cases, factors such as the petitioner age, financial condition, the options of family members, the opinions of the family members, as well as the age and occupation of the parties involved may be relevant for the consideration, friends. After considering these facts, you may decide that what actually happened by the mental disorder. Friends, in a case of Indrajit Singh versus Amarjit Singh, Punjab and Haryana High Court held that wife was suffering from schizophrenia. She need a prolonged hospitalization. The court held that both the parties could not leave the conjugal bliss in such situation. Therefore, this is the case fit under the category of mental disorder, friends. In a case of Sona versus Karambir, a board of doctors gave the opinion that wife was suffering from such mental unsoundness which is not curable. The court granted the divorce because if it not curable, it also affecting the marital relationship. Divorce should be granted to the parties, friends. So this is the condition related with the mental unsoundness. But friends, before starting the next ground of the divorce, I want to recall certain points with you, friends. The point is, mental disorder is one thing, existence of mental disorder and of effect of mental disorder. Friends, in the number of cases, the court decided that presence of schizophrenia is one thing and what schizophrenia does is another thing. Therefore, mere presence of psychological problem, mere presence of mental psychopathic disorder not dissolve your marriage. Nature and degree of mental illness, mental disorder, unsoundness of mind is relevant, friends. On that basis, marriage may be dissolved, otherwise not. So therefore, when we are going to discuss that, we should focus on the nature and effect of mental unsoundness is one point here. And second is friends, whether after due to the mental illness you are able to perform your societal obligation, marital obligations or not. These are the tests. On that basis we are able to draw our conclusion that the marriage should be dissolved on the ground of mental unsoundness, friends. Friends, now I want to focus on the next ground of the divorce, that is venereal disease in a communicable form. Friends, divorce may be obtained by the respondent if respondent is suffering from venereal disease in communicable form. Friends, before the amendment in the year 1976, the venereal disease in a communicable form was a ground of judicial separation, but after 1976 it also became the ground of divorce, friends. As per the provision of section 13(1)(5) provides that a party has been suffering from venereal disease in a communicable form. It is a ground of divorce, friends. Now the fundamental question is, friends, can a petitioner who has caused the respondent illness still be entitled to any legal remedy? Answer is no. Why, friends? A person who is creator of problem cannot take the advantage of the fault, friends. But the problematic point is, friends, how you can determine that, because these are so secret act, and after the disease both person presents the disease, but it is a matter of fact and circumstances and evidence. If petitioner is responsible for the venereal disease, no remedy granted to the petitioner, friends. In the 59th report of Law Commission highlighted that it is not always easy to prove whether two spouses are found to be suffering from this disease, one get infected prior to the other, but no one will take advantage of his or her own wrong or disability, friends. Friends, in order to explain this point, venereal disease in communicable form, which is the ground of divorce, every dispute, the burden of proof shifts from shoulder to shoulder, and its weight also varies from issue to issue. Where the respondent has contracted the disease from the petitioner, the decree cannot be granted on this ground. The Act does not permit the person suffering from venereal disease to petition for the divorce on the basis of his own wrong. Friends, in Sarlabai versus Komal Singh case, MP High Court observed that the heart disease is not a ground of divorce under section 13(1) of the Marriage Act, because venereal disease is one thing, heart disease is another thing. Yes, obviously heart disease is serious disease, but this is not a ground of divorce which is recognized under the Hindu Marriage Act. Friends, now I want to moving towards the next ground of the divorce, that is renounce the world by entering into the religious order. The ground of divorce is available to the party of a marriage if other party has renounced the word by entering into the religious order, for example sannyas. Friends, section 13 subclause 1 subclause 6 clearly mentioned that other party has renounced the word by entering any religious order. Friends, the grounds may be invoked by proving 2 points, friends. The first is either party renounce the word and enter into the religious order. Both must be coexist for the purpose of remedy. Renounce the word and enter into the religious order. This is the point, friends. On that basis we are able to explain the entire story. Friends, according to Hindu point of view, sannyas is very clear. A person may, after discharging the duty of grihastha ashram, may enter into the banprastha and then sannyas. If a person is moved towards sannyas, then obviously this is the ground of divorce, friends. In a case of Sital Das versus Santaram, the Supreme Court mentioned that if a person renounce the word means he should not involved in worldly and material things. So long as a person involved in worldly and material things, he cannot be treated as a person who renounce the world by entering into the religious order. Renounce the world by entering into the religious order. Both the fact must coexist for the purpose of remedy under this section, friends. Friends, no person is regarded as a sannyasi simply because he has entered into the religious order without renouncing the world. This point is very crucial, friends. You enter into the religious order but you not renounce the world, then it is not a ground of divorce. Renounce the world and enter into the religious order. For example, friends, Sikh become Granthi, Hindu become Pujari. It is not necessary and sufficient for the dissolution of marriage. They enter in the religious order but they not renounce the world. Therefore, they cannot consider sannyasi and therefore divorce cannot be obtained against them under the Hindu Marriage Act, friends. Friends, for the purpose of sannyas, Dharma Shastra prescribed many kind of celebrations. The Kumbh Mela is also very prominent place where the number of persons may adopt sannyas. But the important point is whether you renounce the world by entering the religious order or not. If it is not so happened, you are not entitled for the divorce on this ground, friends. Now I want to focus on the person not heard for a period of 7 years. This is also a ground of divorce. Not heard for a period of 7 years. Friends, a party of marriage can obtain divorce on the ground of long disappearance of the other party. The disappearance must be for not less than 7 years before the petition, and no news of leaving has been heard by those who heard him oblique her naturally if he or she has a life. Not heard for a period of 7 years. Then the law generally presume the judicial death, friends. What section 13 subclass 1 provides in this regard? Section 13 subclass 1 subclass 7 has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of it had that party been alive, is a ground of divorce, friends. Now, friends, for the purpose of explaining the provisions, High Court laid down different rules, friends. The High Court rules includes where the petitioner last cohabited with the respondent. Where the petitioner last cohabited with the respondent, that is the reference point how you can start counting of 7 years from last cohabitation. Second, the date and place where the respondent was seen last or was heard to be alive. And the third point is what steps were taken to know his friends. These 3 points for the purpose of ensuring the misuse of this provisions, friends. Suppose, friends, long disappearance, after that a decree passed. Then what will the effect of the decree, friends? The return of the respondent after passing of the decree of divorce on this ground will not affect the decree. And second, either party to a marriage is not entitled to the restitution of conjugal rights when the petitioner came, friends. And remarriage of a decree holder is not a violation of section 5 subclass 1 because he entered marriage after having a decree, and decree is possible under this section, where in these circumstances the court is not going to provide you any kind of remedy judicial separation, friends. Court only grant the divorce decree. Friends, as section 111 of the Bharatiya Sakshya Adhiniyam 2013 draw the presumption in the above circumstances that the person is dead, then you can say that this class is presumed death. but the presumed death is not mentioned under the Hindu Marriage Act. Because in a case of death, there is a no need of petition, there is a no need of formal declaration of court for divorce. But long disappearance required a petition and formal declaration of court. After that, your marriage will be dissolved. Otherwise, automatically marriage is not dissolved. Therefore, this is very important point. Therefore, presumptive death is not used in Hindu Marriage Act. Long disappearance is used, friends. Because when law presume your death, then why we need any kind of decree, friends? Because after the death, other party is free to marry again. But under these circumstances, there must be a formal decree. After that, second marriage is allowed, friends. And if you are violating, then section 7 may be invoked and you may be punished, friends. So friends, these are the grounds which covers under the fault theory of the divorce. Under the fault theory, under section 13 subclass 1, I discussed with you the 8 grounds: adultery, cruelty, conversion, desertion, a mental unsoundness, venereal disease, long disappearance. So these are the grounds. On that basis, divorce may be obtained by either party of marriage if they fulfill other condition. But friends, please recall the section 13 capital A. In certain cases, the court is ready to allow you divorce, but in certain cases the alternative remedy is available. For example, in a case of adultery, cruelty, desertion, the court may allow you judicial separation instead of divorce. But in a case of conversion, presumptive death, or in a case of venereal disease, the court will provide you a remedy which is only divorce, friends. So now I want to focus on the next part of today's lecture, that is the frustration theory of divorce or marriage. Friends, frustration theory means practically marriage is not exist. Practically the objective of marriage is not complied. So therefore it is better to dissolve the marriage instead of continuance of marriage. The circumstances is given in section 13 under bracket 1 capital A. Friends, the idea is very clear and simple. Suppose a decree of restitution has been passed by the court, but after the decree there is no restitution. Judicial separation already passed section 10 of the Hindu Marriage Act, but there is no cohabitation. Decree is still alive, time has been passed. Means although marriage exists on paper, but there is no marriage in fact. Marriage entirely frustrated. Therefore, it is the ground of divorce. You may approach the court as per section 13 under bracket 1 capital A on both the ground. In a case of non-cohabitation after 1 year period or more than 1 year period, this is also a ground of divorce. Now I am focusing on the frustration theory of divorce, which also focused about the divorce under section 13(1) under bracket 1 capital A, friends. 13A provides that any marriage solemnized before or after the commencement of this act may, on the petition presented by either the husband or the wife, be dissolved by a decree of divorce on a ground that other party. First, either party to a marriage, whether solemnized before the commencement of this act, may also present a petition for dissolution of marriage by a decree of divorce on the ground, first, that there has been no resumption of cohabitation as between the parties to the marriage for a period of 1 year or upwards after the passing of decree of judicial separation in a proceeding in which they were parties. And second, there has been no restitution of conjugal rights as between the parties, the marriage for a period of 1 year or upwards after the passing of a decree for the restitution of conjugal rights in a proceeding to which they were parties. So subclass 1 is focus about the judicial separation and second is focus about the restitution, friends. Judicial separation decree has been passed, but there is no cohabitation from the date of decree. 1 year time has been passed. There is a decree of restitution, there is no cohabitation, marriage not exist practically. Then you may utilize this ground for the divorce, friends. Friends, section 13(1) capital A was added through the amendment in the year 1964. The time limit was 3 years by the amendment in the year 1964, but it is amended in the year 1976 and 3 years now reduced up to the 1 year, friends. So now 1 year time limit is given under section 31 capital A. Friends, the present class permits the party to a marriage to petition in which a decree of judicial separation has been passed to apply the court for decree of divorce. The petition may be passed for judicial separation, for the restitution, you may approach the court for resolution, friends. Friends, the decree of judicial separation must be subsisting decree. It should not be rescind section 10 subclass 2. Friends, suppose a decree of judicial separation has been passed by the court in section 10, rescind under section 10 subclass 2, now party claiming divorce on the basis of judicial separation, it is not allowed. Decree of judicial separation must be consisting decree. Then divorce may be granted by the court because 1 year time has been lapsed and there is no cohabitation between the parties. Friends, where the marriage has become unbearable to the spouse, it is just and proper to facilitate them by freeing them from the marital relationship for their happiness, friends. Friends, judicial separation or decree of restitution may be ex parte decree. Ex parte decree not affect your rights to argue your case under this head, friends. Friends, in Saroj Rani versus Sudarshan Kumar case, Supreme Court in the year 1984 observed that on the ground of non-restoration of conjugal rights for a period of 1 year or more after the decree for the restitution of conjugal rights under section 9, we reach on a conclusion without any mental conception because it is evident that whatever be the reason that marriage has broken down and parties cannot longer live together as husband and wife, if such is the situation, it is better to close the chapter and court allow the divorce, friends. Means, friends, if they are not interested to live together, there is no cohabitation after a long time, they successfully obtained the decree of judicial separation, why you are waiting them? Marriage is not practically exist, therefore divorce should be granted. In a case of Jordan Jagadish versus S.S. Chopra, the Supreme Court Justice Chinnappa Reddy observed that Hindu Marriage Act 1955 does not specifically provide for divorce on the ground of irretrievable breakdown of marriage, yet the principle appears to have been recognized under section 13(1)(a). Friends, please recall our lecture where I discussed with you that irretrievable breakdown means the court have extraordinary power to dissolve the marriage. Frustration theory is one thing, irretrievable breakdown theory is another point. Frustration means marriage is not actually exist. The sense of marriage is not actually exist. Purpose of marriage is not actually exist. Frustration, and on the basis of frustration, divorce decree may be granted. But the irretrievable breakdown theory provides special rights to the Supreme Court. Supreme Court may exercise the extraordinary power without any ground, may grant the divorce decree, friends. Friends, now the question is, friends, when does the period of 1 year commence? Friends, 1 year period may commence from the date of decree under section 9 and 10. If there is an appeal filed, So concession is provided in the favor of the party so long as the appeal is pending. You are free not to file a divorce on that ground, friends. Now friends, the rule is that appeal and its dismissal will not count because it is not wrong under section 23(1)(a) of Hindu Marriage Act 1955. No benefits can be granted on the basis of own wrong. Suppose you have a decree of restitution and either party willfully neglecting you, not willing to live together, not willing to share matrimonial home or bedroom with you. After expiry of 1 year, another party approaching the court is not going to award divorce to particular person. Why? Because of the fault of the person, they not united, friends. Means if the fault committed by you, you cannot take the remedy of section 13(1) under bracket 1 capital A of Hindu Marriage Act. In a case of Dharmendra Kumar versus Usha Rani, the wife was granted the decree of restitution of conjugal right under section 9 and after 2 years, she filed a case of divorce. Husband stated that wife herself refused to receive or reply to letters written by him. The Supreme Court held that the conduct of the party before the decree is not relevant. Supreme Court adopted over a lenient attitudes towards the decree holders in a case. She herself defects the efforts of restitution. Friends, some important rules is also there for the purpose of explaining the idea. The rule is serious. Single misconduct is enough to justify the denial of relief. No automatic divorce after the expiry of 1 year time. No divorce available on the basis of impotency under this provision. Under section 13(1)(a), not bar the other ground. Suppose if you file a petition under this ground, you may also file your petition on the basis of other grounds, not bar you taking other grounds, friends. The principle of res judicata under section 13 under bracket 1 under bracket 1 capital A, dismission of petition for the divorce under section 3 does not operate a bar on other grounds. Suppose you filed a petition under this section, court is not provide you remedy of divorce. Then principle of res judicata and constructive res judicata will not prevent you for filing divorce on another ground. So therefore, under this section, the principle of res judicata and constructive res judicata will not apply in this case, friends. No divorce mere on the ground of separate living, friends. There must be a decree for separate living, friends. So now, friends, we may think about certain point. Can a single act of cruelty be enough to dissolve a marriage? How to reconcile the provisions under section 13(1) under bracket 1 capital A to seek divorce with societal emphasis of preserving the institution of marriage, friends. By this discussion, friends, I want to summarize my today's lecture. Friends, I discuss with you mental unsoundness as a ground of divorce, where I discuss with you an important point. Presence of disease is one thing, effect of disease another thing. Presence per se not provides you grounds. Effect, therefore, nature and gravity and the consequence of disorder, illness, psychopathic disorder, schizophrenia is important for the purpose of divorce. We also discussed that venereal disease, communicable form. Disease must be venereal and disease must be in communicable form. Heart disease comes not under the category, friends. But very important point is, suppose a person itself responsible for the venereal disease cannot take the advantage of this ground, friends. Or be careful. Suppose if one party of marriage suffering with venereal disease cannot file an application for the divorce, because no person can take advantage of wrong or disability under these provisions. If you are suffering, other party is entitled to file divorce. You are not entitled to file divorce. Now, friends, we also discussed that renounce the world and enter into the religious order. entering into the religious order in the form of Granthi and Pujari is not sufficient. Renounce the world means sannyas, means you are not interested in the worldly affair and material gain. It is the ground of divorce. And friends, long disappearance, and this disappearance must be more than 7 years. Judicial death is not mentioned because after the death there is no need of decree, but divorce is very clear, friends. Without the presentation of petition and without the formal declaration of decree, no marriage can be dissolved under Hindu Marriage Act. This is the important point to be noted, friends. After that, friends, we also discuss the frustration theory of divorce, where I discuss the certain points, section 13 under subclass 1 and under bracket 1 capital A. This is the frustration theory of marriage. Means a decree of judicial separation is already passed, a decree of restitution of conjugal rights has been passed. 1 year time or more than 1 year time has been expired. There is no cohabitation between two parties. Then it provides a ground for the divorce. You may file the petition for the divorce and court will not wait. Court will not wait. And if you file the petition, the court will dissolve your marriage, friends. But the important point is, friends, in this context, the principle of res judicata and constructive res judicata will not apply. Means, suppose if your case was rejected by the court, you may file another petition for divorce on other grounds mentioned in Hindu Marriage Act, friends. So this is the ground, friends. But friends, we also discussed that suppose if a person, due to the conduct, there is no cohabitation, a person cannot take advantage of misconduct. We discussed these points and we understand the different ground of divorce. Thank you, friends. Thank you. Thank you, friends.